Hello everyone, immigration lawyer Mustafa Cetin here. Today we're talking about a bombshell of a legislation that would shake the immigration practices. Laken Riley Act. Bear with me. What is Laken Riley Act? Laken Riley Act is a piece of legislation offered by the Republicans back in March 2024 that would pretty much change a lot of things when it comes to enforcement of immigration law, prosecution for immigration purposes. This is going to be a little bit technical, so bear with me here. I'll be breaking down the elements of the piece of legislation. But first of all, let's talk about who is Laken Riley. As you know, the US politics have a phenomenon, which is capitalizing on a specific incident to come up with a piece of legislation, to ride on the popularity, so-called popularity of that event. Usually these events are tragic, and in this case, Laken Riley was a nursing college student in Georgia. Unfortunately, she was killed by a undocumented immigrant who was processed and led into the country back in 2022. Name is Jose Ibarra. As of now, Jose Ibarra has been convicted of this crime. You gotta give credit where it's due. The Republicans are pretty good when it comes to pulling off these political maneuvers. Capitalizing on something like this is, I think it's a good idea to get your legislative agenda done, to convince everyone to act. But it may not seem, even though it's packaged as something appealing to a lot of people, in reality, the technicality of it is completely different. I gotta tell you, as an immigration lawyer who's been practicing for a long time, this could shake how things are done for immigration purposes. As to why, I'll be explaining. Let's talk about how likely this piece of legislation is to pass. It was introduced back in March 2024. An act of the new Congress, just before the president is sworn in, was to pass this again and send it to Senate. So the Congress, as you know, consists of House and Senate. House passed this, sent it over to the Senate. Now, as you know, Senate has a filibuster arrangement. If an opposing party member doesn't want a piece of legislation to pass, they can do a filibuster and block it. You cannot bypass a filibuster with just simple majority. You will have to have 60 senators to sign off for a measure like this. Right now, Republicans have 53. Publicly, 4 Democratic senators announced that they will be joining this act. They will be signing off on this. So Republicans need 4 more. I think it's very likely that this could pass the Senate and the president can sign off on this right after he's been sworn. So there's a very good possibility that this could happen. Now let's talk about the specifics of Laken Riley Act. Laken Riley Act consists of amendments in 2 different categories. The first category has to do with mandatory detention. It specifically changes this section of the law, Section 236, regarding detention of criminal aliens. Section 236 breaks down when someone who is going through removal proceedings is subject to mandatory detention. So the mandatory detention is a term of art we immigration lawyers use. It means when you're going through the immigration process, the removal process, where the federal government is arguing for your removal from this country, you are subject to detention and you cannot be released. You don't have the opportunity to ask for a bond. In normal circumstances, you are entitled to. Or you cannot be paroled. Even if the federal government wanted to, they cannot exercise discretion. Right now, without the amendment, the statute says another term of art, CMIT. Someone convicted of a crime involving moral turpitude is subject to mandatory detention. Another term of art, being deportable, I'm not going to get into it, is also subject to mandatory detention. So here's what is changing. Here's what is being introduced. This new paragraph, subsection E, talks about being inadmissible under 212A of the Act. It refers to 6A. It refers to 6C. And it refers to 7. Without going into too much details, I can tell you this. 6A is about someone who is inadmissible because they crossed the border. They entered the country without inspection. 6C talks about misrepresentation. Someone who dealt with an immigration officer at any point, this could be in the Department of State context when you're applying for a visa, and who's been found to have made a misrepresentation, lie. Okay, that's the first condition. If you meet under these categories, and if you are charged with, careful here, charged with, arrested for, convicted of, admit, which is very important, committed, or certain elements which constitute burglary, theft, larceny, and shoplifting. This is such a big deal. I cannot tell you how controversial this is. It's a global principle of law. It's a global standard that being accused of a crime doesn't mean that you're guilty. You are innocent until proven guilty. Apparently, when it comes to immigration prosecution, that's not the case. Just being charged with a crime, just being arrested is enough. And it doesn't have to be a specific crime. If you just talk about it in an enforcement setting, and if you admit to anything that constitutes burglary, theft, larceny, or shoplifting, can you imagine how common shoplifting is? All throughout the country in shopping malls, corporations have people, security personnel on payroll to prosecute shoplifting. And just being accused of shoplifting is enough to trigger mandatory detention for immigration purposes. Obviously, this is going to be subject to huge legal challenges. I think it would be fair to say that it's going to make it all the way to Supreme Court in terms of constitutional challenges. And I think this other edition here is put in here to curb any argument that would say this statute is too vague. It's unconstitutional because of vagueness. It says terms burglary, theft, larceny, shoplifting have the meaning given such terms in the jurisdiction where the acts occurred. So this is very important. When it comes to criminal immigration practice, immigration consequences of a criminal act, our biggest challenge, the most technical issue we deal with is what constitutes a crime involving moral turpitude. It depends on, crimes are usually defined by the state statutes. So no one knows with reasonable certainty what constitutes a crime involving moral turpitude. In other words, what kind of crime would have immigration consequences. Now with this piece of legislation, with these new amendments, it's not vague anymore. It's pretty clear. It directly refers to state statutes. So in that sense, I think this is put in here to curb any constitutional vagueness arguments. Now, another important thing. Detainer, which is another term of art where someone is charged on the state level and the federal government, for immigration prosecution purposes, steps in, and before someone is released, they ask the state authorities to deliver the custody of someone. This is what we call a detainer. So detainer, right now, prior to this amendment, it is discretionary. There are millions of people around the country, I can tell you, where the federal government chooses not to prosecute for immigration purposes. These people could be those without an immigration status. It could be those with a removal order, pending removal order. But maybe one of the most important changes this piece of legislation, Laken Riley Act, brings is it makes it not discretionary anymore. It says, shall issue a detainer. Now, you can say, what about the federal government, maybe another administration, maybe another democratic administration, democratic president, doesn't choose to execute this? Here's when it gets tricky. Usually when it comes to federal immigration litigation, there is no authority for the states to sue the federal government. Well, there is, but jurisdiction is limited. There are things like Administrative Procedure Act, where it gives the states general standing to legally challenge an action by the federal government. Now, this piece of legislation here, this amendment, changes that completely. Flat out, it gives the states the authority to sue specific actions by the federal government. And we're going to talk about in different contexts. This language is introduced in not only mandatory detention, but other provisions of law, which I will be breaking down soon. So in this sense, it is huge. It is going to change the practice of immigration law as we know it. So what is the federal government doing here? The federal government is deciding on, doing something or not doing something. And then a state kicks in, like a conservative state like Texas or Georgia or whatever. And they say, hey, I have been harmed maybe just financially, just for $100. My harm is not that big, but that gives me the jurisdiction to sue you, the federal government, and bring this action in an appropriate district court, file immediately, and get an injunctive relief. That means that they don't have to go through the whole process that federal rules of civil procedure entails. In this sense, it is huge, and the law says it has to be expedited, very fast, greatest extent practicable. So in this sense, whenever a specific individual is involved, state governments would have the opportunity and the jurisdiction to sue the federal government for the specific individual and get an injunctive relief immediately and get that individual detained. So this is huge. Same dynamics apply to other areas of immigration law by way of different provisions, which we will be breaking down right now. This provision, 212D, is about humanitarian parole. So the parole has been discretionary. It is discretionary. The federal government has the discretion to parole a group of individuals into the country. Latest examples of this have been in the case of Ukrainians because of war, Venezuelans to a certain degree, Haitians. Federal governments, the past administration, utilized this authority, this discretion, in a different number of ways. And this has been heavily criticized by the conservatives, by the Republicans. And this authority by the states to bring federal action against the federal government's exercise of parole authority comes in here. It says the Attorney General of a state or authorized state officer, anyone basically, alleging a violation of limitation under subparagraph A, that parole solely be granted on a case-by-case basis and solely for urgent humanitarian reasons or a significant public benefit. Basically, they're saying, oh, this harms me, and I'm challenging your action. This before was not subject to challenge. I mean, it was, but not in this sense. This brings in a very increased sense of power to the states to challenge the federal government's actions, their discretion to parole, come up with different parole programs in the future. And this piece of legislation probably is going to be permanent. And it says the bar is really low. Just again, financial harm in excess of $100. And same procedural advantages apply. Moving on, another category of the same thing, which is another category where states have this power. Expedited removal. Expedited removal has been very controversial during the first administration of this upcoming administration. You know what the name is. And expedited removal is very important because it subjects someone to a very fast way of being removed from this country. And in that sense, the only way the federal government cannot do this is if that individual successfully goes through credible fear interview. So this specific provision, 235, is about that. And here we go again with the same provision. In the case of a specific individual, the state governments can again file and bring injunctive relief. When you think about this power, it is huge in terms of, think about it, someone being subject to expedited removal or not, someone passing the credible fear interview. We cannot challenge that when it's negative. Believe me, I try. I wanted to. I tried that, but jurisdiction comes up, and lack of jurisdiction is most common reason for our actions, our lawsuits to be denied. That's not the case anymore for the state governments. They will have jurisdiction and they will have the procedural advantages not to secure a decision, just to secure injunctive relief. In this sense, this is huge. Moving on. Detention of someone with a removal order. Remember what I just said about people with a pending removal order, a final removal order, millions of people. This provision says, 241, detaining someone is discretionary for the federal government, even if they have a final removal order. You can see people who live out their lives for decades with pending final removal orders. They go into supervised meetings at certain intervals periodically and live out their lives In other words, the federal government chooses not to remove them from this country, but that is not going to be discretionary anymore. Now with this, same provision, federal government could be forced to take action. Let's say there's an individual, again, a conservative state coming in and alleging, hey, I have been harmed financially by the specific individual. He has a removal order. I am filing an action in the federal district court of, I don't know, Texas, Georgia, against the federal government. Federal government must be, there is an injunctive relief. And it says, federal government, you are supposed to detain this individual and prosecute them. Moving on, same authority in a different context. This time, Section 243. Section 243 is about the efforts in large-scale logistical efforts of the federal government to remove citizens of certain countries. And this gives the federal government the opportunity to do what exactly? To put it simply, a specific country is not cooperating with the removal of a citizen, a national of that country. This section gives the federal government the authority to discontinue granting immigrant visas or non-immigrant visas, basically all consular operations, to that nation, to that country, country A, let's say. And here we go with the same provision. A state alleging, and this will be most likely utilized in the case of countries where, you know, most of the immigrants come in, undocumented immigrants come in, let's say Central America or South America. A state goes out of their way, uses this provision, procedural advantages, and successfully argues that, hey, federal government, stop processing visas to, I don't know, Honduras, to, I don't know, Costa Rica, oh, I don't know, Venezuela. So in this sense, it empowers the states in a way that we haven't seen being implemented so far. And if this legislation passes, pretty much a lot of things we know, as we know it, in the immigration practice will change. Bear with us, keep watching, please subscribe and share, stay up to date with the immigration updates from the new government, new administration. Thank you for watching.